answer that so that I can take another one if there is. The Martin Charo case for me was a well-decided case. And in this matter, I align my thoughts with those of Justice Chitembwe, Justice Majanja, and Justice Macau. Because, for example, with the Martin Charo case, you know, the young lady or the young girl, when she was being cross-examined, or when she was being asked questions, all right, she said that I know the accused, I have known him for 3 years, and I went to his house. So when she was asked, what did you go to his house to do? She said, I went to have sex and go back home. All right? You're the judge in this case. I mean, this is somebody who knew what she went to do. This is someone who has known the accused person for 3 years, right? They've been in a relationship. Yes, the boy was 22 or so at the time, at the time of commission of the offense. The girl, I think, was about 14 or so years of age. But for me, the reasoning of Justice Chitembwe was anchored on Section 8.5, because Section 8.5 of the law of the Sexual Offences Act stipulates that where the child, right, makes the accused to believe that she was of age, right, then the court must have or must take into regard or must take into consideration the belief that the accused was made, or rather that I mean must take into consideration that the fact that the accused was made to believe that the complainant was of age. So for me, I think that was a judgment that was well put. It's a judgment, of course, it's controversial, because for us as a society, there are certain areas that we never want to have objective conversations about. You know, we never want to have objective conversations about religion. We never want to have objective conversations around issues pertaining to abortion, issues pertaining to sex. But you see, there was this famous judgment, you know, by the National Gay and Something Commission, you know, where just to quote, I think it was Justice Koome, if not, then it must have been Justice Anna Okwengu. She said that as a society, we can choose to bury our heads in the sand and pretend that we do not have gay people and lesbians amongst us. But the real truth is they're there. I want to borrow those words. We might pretend and you know, assume that girls and young boys are not having sex and they really don't know a lot about it. But the reality of the matter is 6 out of 10 young people in this country are sexually active. That is the reality. That is the naked truth. The only thing that we need to do, because the other argument that has been put forth is that instead of only charging the boy, then we also need to take the girl to court. What would be the ripple effect of that? I think if we take that direction, because ideally, both the boy and the girl are at equal fault, ideally. But if we take that direction, then we are going to end up criminalizing an entire generation. 6 out of young people are sexually active. So you just put your mind to a situation where all these 6 out of 10 young people are found and are taken to court. We shall have locked in behind bars an entire generation. So for me, I think we need to, much as it's a moral issue, but we need to, in this case, reform our laws so that we are able to save the next generation, in my thinking.
Thank you. Anyone with a question, you can raise your hand using the reactions below. Secondly, Council, what do you think about that section? Do you feel like it discriminates on the boy child? Because now the boy child now gets the punishment and the lady goes scot-free. I don't know. What do you think about that? Thank you.
It is discriminatory, and it was once an issue in the case of CKW versus Attorney General, you know, where also a young boy had been sentenced for having consensual sex with a girl who was 16. They were both 16 years of age. So being aggrieved with that decision, he appealed or he petitioned the High Court to have Section 8.1 and 11.1 of the SOA declared unconstitutional. Well, the court never really did, but in my mind, as a legal practitioner, those provisions are discriminatory, because then it flies in the face of Article 27.4 of the Constitution, and also Article 53.2 about the best interest of the child. You know, that article stipulates that the best interest of the child is paramount in all circumstances. So in having only the boy being locked in or being sentenced, in my view, it's discriminatory and it's unconstitutional. I mean, and unless we reform it, really, it will be using a law that is unconstitutional to punish people.
Thank you for that. Anyone else with a question or a concern? I can see Margaret was asking, let me just go to the charts. She didn't get the consensual age of, oh, Margaret, you can speak, then Tree. You can just